Welcome to another episode of Trial Site News. Today we're going to be talking about the Pfizer vaccine lawsuit case, which is involving the COVID-19 vaccine. And what is Pfizer's defense strategy here? Well, that the contract status offers them immunity. What? So we're going to be talking about what is happening here. And so, from Trial Site News, I am Adrian, and our episode is starting right now. So, Brook Jackson is suing Pfizer under the False Claims Act. Ms. Jackson claims that while developing their vaccine for the coronavirus, Pfizer cut corners in their clinical trials, wasting taxpayer dollars, violating federal regulations, and possibly endangering Americans' health. Ms. Jackson claims that in the, quote, race to secure billions in federal funding and become the first to market, the defendants, Pfizer, deliberately withheld crucial information from the United States that calls the safety and efficacy of their vaccine into question. Ms. Jackson also went on to say that the defendants concealed violations of both their clinical trial protocol and federal regulations, including falsification of clinical trial documents. Due to the defendant's scheme, millions of Americans have received a misbranded vaccination, which is potentially not as effective as represented. The vaccine's U.S. Food and Drug Administration authorization resulted from a deeply flawed clinical trial that violated FDA regulations. The defendants have profited from the COVID-19 pandemic at the expense of the United States and its citizens by abusing the scientific process." Unquote. Now, Pfizer has proposed in their defense in the lawsuit charging them with vaccine study fraud that there cannot be any legal culpability associated with the charged violations, with certifications to the federal government as part of the contract in response to the COVID-19 vaccine. Why? Well, as mentioned at the top of the program, Pfizer is claiming that the federal contract status offers them immunity from such claims. The pharmaceutical company is seeking to dismiss the lawsuit brought on by the whistleblower Brook Jackson under this premise. Now, who exactly is Ms. Jackson? Let's take a look at her for a minute. Well, she worked for a contract research organization called Ventavia Research Group on the pivotal Phase 3 Pfizer COVID-19 vaccine study. She alleges that she witnessed many critical, compliance-violating anomalies needing immediate attention. She emailed the complaint concerning alleged violations of good clinical practices, as well as various compliance frameworks and laws, to the U.S. Food and Drug Administration back in September of 2020. However, the executive branch agency in charge of enforcement of alleged violations simply opted to not open an investigation into the matter. And so the study continued, and Pfizer didn't make any adjustments working with Ventavia. However, the CRO did fire Ms. Jackson shortly thereafter, alleging involvement with fraudulent manipulation of data and other allegations. Now, as we here at Trial Site News have reported, Jackson opted to take legal action here, filing a lawsuit in the United States District Court for the Eastern District of Texas, Beaumont Division, alleging a violation of the False Claims Act. The plaintiff sought action for the violation of federal laws and associated compliance standards, such as good clinical practice. Now, it is also worth noting that the U.S. Department of Justice opted to pass on any involvement. And during the case, Ms. Jackson violated a gag order and lost her attorneys in the process. However, she was picked up by attorney Robert Barnes shortly thereafter. Pfizer argues that thanks to a procurement clause known as the Other Transaction Authority, or OTA, associated with Department of Defense-related contracts, for example, the pharmaceutical company isn't liable for the standard federal procurement rules governing such contracts. So that raises the question then. Does Pfizer get a pass from the rule of law for violating laws and rules as alleged by the plaintiff and her attorney? Well, according to Jackson's attorney, this case could be the biggest False Claims Act whistleblower case in U.S. history. So now let's take a step back and look at some of the background here. Back in November of 2021, we here at Trial Site News reported that the prominent medical journal, the BMJ, reported on the Jackson situation with Ventavia and Pfizer. And in what is becoming more and more commonplace in the era of social media censorship, which we here at Trial Site News have experienced ourselves numerous times on multiple social platforms, the BMJ, one of the most prominent medical journals in the world, was themselves censored by Facebook fact-checkers. Why? Well, because they reported on the allegations of fraud, including the prospect of data manipulation associated with the COVID-19 vaccine trials. Now, to their credit, the BMJ fired back at the social media giant with a message to Facebook saying, "Stop censoring us and shut down your incompetent fact-checkers." Meanwhile, while all of this is going on, we also followed the lawsuit to compel disclosure of research and development and regulatory documentation associated with the Pfizer-BioNTech vaccine. It was initiated by a Freedom of Information Act, or FOIA, request by the Public Health and Medical Professionals for Transparency, a nonprofit which sued after rejection thanks to the support of attorney Aaron Siri of the law firm Siri Glimstad. Now, at one point during the dispute to compel document disclosure, the FDA proposed holding the documentation for an outrageous 75-year period, releasing only 500 pages per month, which is beyond infuriating for those who want to see the data. If the FDA had gotten its way, it would mean that the documents wouldn't have been fully viewable until 2096. But thankfully, back in early January, United States District Judge Mark Pittman ordered the release of the documents in batches of 55,000 pages per month over the next several months. And what follows is perhaps unsurprising, as reported by Sonia Elijah here on Trial Site News. The release of artifacts from the trove of Pfizer documentation revealed a series of problems with reported errors and anomalies. So now let's go back to the Brooks lawsuit. Well, as mentioned at the top of this program, Pfizer has made a move to strike down the lawsuit, filing a motion to dismiss, declaring that it cannot be at fault for misrepresentation, misuse, and other claims associated with the BNT162b2 clinical trials due to its accord with the U.S. government itself. They claim that this permitted them to bypass guidelines as well as health and human services administrative regulations associated with standard government contracts. So is there any merit to this? Well, according to the Epoch Times, they recently reported on Pfizer's move to dismiss the case, declaring that the regulations raised the standards during the lawsuit simply don't apply to them. The deal Pfizer inked with the U.S. Department of Defense falls under the OTA, or Other Transaction Authority, enabling those contractors to evade many of the normal laws, rules, and policies that apply to government contracts. According to the government research organization, OTAs include, quote, procurement instruments other than contracts, grants, or cooperative agreements enabling flexible business arrangements to acquire research and development to support technology advancement or to quickly develop a prototype. Many laws and regulations governing federal contracts do not apply to OTs, i.e. Federal Acquisition Regulation and the Competition and Contracting Act. However, the Procurement Integrity Act applies, and competitive practices are applicable. OTs may be protested to the U.S. Court of Federal Claims, and GAO has limited jurisdiction to review OT decisions. Now, in court, the defendant, Pfizer, declared that the demand that they comply with federal acquisition was simply, quote, wrong. So what does Jackson's attorney, Robert Barnes, have to say about all of this? Well, he said in an interview that, quote, what is fascinating is that Pfizer has moved to dismiss the case, and their ground to dismiss, as they repeated in the scheduling conference we had this week, is that it doesn't matter if they submitted fraudulent certifications to the government. It doesn't matter if they submitted false statements under penalty of perjury to the government. It doesn't matter if they lied about the safety and efficacy of the drugs, because the government was in on this with them. The government knew what was going on, and the government is going to give them a check anyway. So, is it really fraud if the government is a conspirator? That is the essential Pfizer defense so far. Now, in what is considered a victory for the plaintiff, Barnes reported that the judge has declared the plaintiff is entitled to discovery in relation to the motion to dismiss. Attorney Barnes shared in his interview, posted online, that Pfizer went, quote, ballistic, because the plaintiffs, according to the judge, have rights to discovery in a timely and material way. And so it would seem that Attorney Barnes, in suggesting that Ms. Brooks' case could be the biggest whistleblower False Claims Act in history, could be onto something. But no matter how you look at this situation, it is deeply disturbing and troubling that this has managed to evade the public eye for so long. This probably has a lot to do, though, with the fact that social media has been in on all of this and keeping information suppressed with the whole trusted news initiative. In any case, though, we of course will be keeping an eye on the story as it continues to develop both on trialsitenews.com and here on the YouTube channel. And that, my friends, will bring our episode to a close once more. As always, thank you so much for joining me on the program today. From Trial Site News, I am Adrian, and I will see you all